Hello friends, this is Vishakha Daga coming up with next round of editorial explained. Now it is said justice delayed is justice denied, and it is true. And if that is true, then we have been denying the justice to nearly 3.93 lakh crore people in our country because of judicial pendency. It is a very important case. Sasadhar Biswas case highlights the same thing, and it is a very curious case which actually highlights the why the judicial pendency is happening in our country. And this article is covered in Indian Express that we're going to discuss today. We will discuss this article in detail from the beginning itself. But before, which is actually highlighting how Code of Civil Procedure has caught the delayed injustice. Before beginning this article, let's understand the state of affair in the country itself. If we see that in Article 21 of our Constitution prescribe that right to justice is one of the fundamental rights of our country. But this right is denied because the judicial pendency in our country is 3.5 crore cases, of which the 87% are lying in district and subordinate case, which are in numbers are 2.9 crore, which are 49 lakh at High Court level and 57,000 at Supreme Court level. This is the sorry state of affair to the extent that it results in a data where at an average it takes 50 years for any case to be disposed in our country. At an average, it takes 15 years for a case to be disposed in our country. This is a very sorry state, because many a time what happened before a person gets the justice, he's dead in the books of the legal books, which need to be improved. This thing is also highlighted in the recent Sasadhar case, which is being discussed in this article, and a very curious article this is, where it has been 5 rounds of 50 years and still nobody has got the justice. This article says this was such a simple case that even having a first look at the law book, even having a first look at the evidences of the cases, you could have simply said that, this person is guilty and he need to pay this to particular your victim. But even then, despite being such a simple case, it took 50 years, and even then nobody has got the justice. To the extent that one of the judges says that this case could have been actually in the law book of the student, highlighting how CVC are being misused in order to prevent the justice to the people. Also, this can be in museum of the, if ever displayed, that how judicial pendency is happening because of the various fault in a legal system. So let's discuss the case, what it is, so that you can understand it. The case started nearly 50 years ago in 1971 when Sasadhar Biswas, he was a resident of the West Bengal. Sasadhar Biswas needed some money, so he went to Ramabai and took 3,000 rupees for him. But he had no intention of paying back to Ramabai. Ramabai actually she had some faith in the judicial system at that time. So she directly went to the court and she asked for the justice from the court only. So this started in 1971. And till it took 4 years for the judiciary to finally decide that in 1974 that Sasadhar Biswas had to pay to Ramabai back 3,000 rupees. But what Sasadhar Biswas did was, he said he does not have money. Now Ramabai again went to the court and asked for the justice. Then finally in 1975 it was decided that Sasadhar Biswas has some land on its name. It need to be auctioned and the money need to be given back to Ramabai. 1975 that happened. Sasadhar Biswas again went to the court against the auction. Then court again decided that no, the auction will take place, and this took many years. That finally in 1979 that auction happened, and Mukherjee brothers, they were 2 brothers from the same place, that who bought the land for rupees 5,000. Right? So the of which 3,900 were to be given to Ramabai. Now you may think Ramabai may have got the justice, but that did not happen. This is just first round only. Many similar rounds came back, like from 1980s to 1990. What happened is this Sasadhar Biswas went to Mukherjee brothers and made a deal with them, excluding the Ramabai. He said to the Mukherjee brother that I'll pay you money, but you actually cancel the auction. And this happened without the court consent. And it took court 10 years again to decide that this entire process was illegal when Sasadhar Biswas did not take Ramabai in confidence, and entire thing happened. Finally, in 1992, what happened was court decided the act was illegal and auction should actually take place. Then again petition was filed at again against auction, which was again denied. Finally, till 1992 to 2001, next petition was filed against the selling of certificate, which was again denied. So this happened for next 10 years. Then from 2002 to 2005, this Mukherjee brother went to the court for the possession of land, because in that amount of time, what Sasadhar Biswas did was he built a property on that land, and he was not willing to vacate it. So Mukherjee brother went to the court to get the possession of the land which was actually sold to the Mukherjee brothers. They did not. And this is the fourth round we're talking about. The fifth round is still in process, and sixth can even happen. And right now, it's not even Ramabai who's alive. The heirs are fighting the case. They are dead. So this is a classical case at how using the civil procedure code, simply using the civil procedure code, actually the justice is being denied. This case was so simple that simply by having a look at the evidences and having a simple understanding of the laws of the country, you can have given a judgment. So the article says that it is a 50-year-old case, it is the rules and proceeding which were made to provide the justice to the people are actually being used to cause the travesty of justice. It is because of them that justice is denied to the people. Then article use very good lines which you can use in any exam if you're writing, that if justice hurried is justice buried, then justice tarried is also justice buried. In hurry, you may actually vindicate a very innocent person. You may actually send him to gallows. This is a mistake you might do, and that is actually a travesty of justice. Then a tarried justice, the justice which is actually denied to people because of long time, is also buried justice. Because in this case, it's a very typical example which happened in many cases, that victim is dead by the time you are pronouncing a judgment. So this is a buried case. So article does not stop in there. It just does not highlight the problem. It actually gives some suggestion. It says you need to prevent the intentional just delays, because here what happened is one of the litigant, he knows for sure that they are losing the case because the primary evidences are suggesting the same thing. So what they're doing is they're just buying their time by misusing the rules, and this is what you need to prevent. So what you have to do is plug the loopholes in the code of civil procedure which is being misused so many times. Though an amendment had taken place in 2002, but the article says that this is not a very effective amendment and you need to work on it. Work on in terms of these kind of loopholes can be plugged out with the serious case studies and serious studies of the CVC. The article gives another forward-looking judgment, which is a very good forward-looking suggestion which you can think of is, it says that in case of trivial cases, with just by having a look at the evidence, you can decide the case. It's better that artificial intelligence takes the decision than a judge, by which you're actually freeing a judge to look after more important judgment which does not require more thinking about it. But a simple providing a data can help them. If you remember, I made a video on Faster and Supes where I talked about how technology can help judges. In Supes, I said the judges can be given a help of artificial intelligence, where the data and the the previous judgment can be given to a judge who's actually pronouncing a judgment of the similar cases, and based on that data, a judge can take a judgment more easily, more informed manner, in more timely manner. Okay, but remember in Supes I said the judge are using artificial intelligence in order to get the data and the previous judgment, but artificial intelligence was not taking a decision. But the article is moving a step ahead. Article is saying, it is saying the artificial intelligence can also be used for taking decision, and the judges instead can focus on more important cases. So by which you can deal with judicial pendency, because one of the judicial reason for the judicial pendency is that non-appointment of judges at time. So even if you have lesser number of judges, you can pronounce the judgment. So this is a very, you're going a step ahead in there, and that's why you need to think about it. But this is a very good actually suggestion you can put anywhere. Now, if you think that is the case, then like and subscribe the video. If not, then put your comment in the comment section and we can make some improvements in it. Thank you so much.
Current Affairs by ForumIAS is an all-in-one program that covers the dynamic aspect of the syllabus from both prelims and mains perspective. Last year, we have helped more than 100 students crack IAS with our current affairs classes.